Good morning, everyone, and thank you for making the time to attend this webinar on GDPR. My name is Jenny Pennington, and I'll be assisting my colleague Sarah Dommett during this webinar. Sarah is a data protection officer and has over 5 years' experience in the data protection field. Before we continue, I'd like to say a big thank you to Intraland for recommending us, and Nat Timon, the engineering manager, who's also on the webinar. To facilitate a Q&A session at the end of the presentation, please make use of the text box at the bottom of your screen. The questions can be anonymous, or you can share your name. It's up to you. Without further ado, I'll hand over to Sarah.
Good morning, everybody. As Jenny said, I'm Sarah Dommett. Thank you for joining us on this call. Today, what we're going to talk about is GDPR and what that means to businesses and how businesses can start to look at complying with the regulations. So the General Data Protection Act, the General Data Protection regulation is coming into force in May 2018. The ICO have very helpfully given us the 12 steps to success, and some of you may have come across this document. This is what we're going to focus our presentation on, because the 12 steps to success really break down into easy bite-sized chunks all the bits of the regulation that you as a business really need to start thinking about and start working towards if you haven't already. So as you can see on the screen, hopefully, the 12 areas that we're going to discuss today are awareness, and that's around awareness of the GDPR itself, the information you hold, so what information have you got within your business, communication, and that's all about how you communicate to your data subjects, individual rights. Under the GDPR, there are some new rights that individuals have, and some of the existing rights under the Data Protection Act have been strengthened. Then we've got subject access requests. There's been some changes made to those, and the legal basis for processing. So this is around what is the legal purpose for you processing the data that you collect. And the next step is consent. And then we have children. So if you direct any services to children, this section will apply to you. Data breach, protection by design. So this is all about thinking about privacy from the very beginning of everything that you do. Data protection officer, and when you need to appoint one and whether you don't. And then international. So this is about any kind of transfers overseas. So we're going to go through each of the 12 steps individually. And the first thing that we're going to start with is awareness. So with the GDPR, there is a slight difference at the moment with the Data Protection Act currently. The Data Protection Act doesn't really give you give the culture of awareness and privacy. It's kind of, at the moment, you comply with the Data Protection Act and then you forget about it and you carry on with your normal day-to-day business. The GDPR really drives home the fact that compliance only really starts top down. So as executives of a business or board members of the business, you have to be fully aware of what GDPR means for your business and how that impacts the business and the data subjects that you process personal information for. You also need support from board level for time, money, resources to start your road to compliance with GDPR. There are some consequences, and executive members and senior management need to be aware of what those consequences are. And the consequences are in the forms of fines and offences that have been set out through the GDPR itself. And some of the fines you've probably heard being battered around. You can get charged up to 4% of your global turnover for a data breach where you've been negligent within that data breach. So the data breach happened because you haven't got in the business the appropriate controls and security measures in place. You can then get fined up to 2% for any administration offences. So if you haven't got your documentation correct, you haven't got policies and processes in place about how you handle the personal information that you process. It also covers training your business, training your staff, making sure that they're aware of GDPR and what that means to them in their daily roles. So whether that be your frontline staff, they're taking calls from customers, whether it be back office staff, what does it mean for them in their role to process this personal information of data subjects? The next step is information you hold, and this is the big one that everybody is talking about, and you may have heard people talking about data mapping, data flows, data audits. And this is where most of the work will come for any business, because you have to now understand what data you hold within the business and where that data is. So where is it stored? How do you process it? Where do you transfer it to? Do you transfer it to any third parties? Does it go overseas? And you really need to start looking at that as soon as possible, because this is the biggest piece of the GDPR. It's the biggest change in terms of you've really got to understand what data you collect, even in the deepest, darkest recesses of shared folders that you've probably not thought about for years. You now need to understand what's contained within those folders. Do you still need that data? Once you have done the data mapping and the data audit, the other steps within the 12 steps that we're discussing today really become quite fluid, and you're able to use the information you hold and the data audit as a springboard, essentially, for your roadmap to compliance. Because once you know the data that you've got, you can then start to communicate effectively. You can then start to understand the individual rights that apply to you and your business in terms of the data you're processing. You really need to start thinking about how you process that data and who you share it with and what they do with it. So if you share it with a third party, what do they do with that data once you give it to them? Have we got within the business appropriate contracts and written instructions for those people? If you're the data controller of this, of the personal data, so you own the data, you decide what happens with it, and you're sharing your data with a processor for them to process on your behalf. So for instance, a marketing campaign, you're still the accountable, the business rather is the accountable entity for that data. So you really need to make sure that you're processing contracts with any third parties, really kind of set out the accountability, and that they only do with that data what you've kind of contracted with them to do. So you have to have a set of written instructions to the data processor. So once you understand where your information is held, you can then start to look at the individual rights that the data subjects will have. And on the screen now, you should be able to see that there's 8 rights that an individual has for their data. So when you process data within the business, the individual has some certain rights about how you process that data. So they have a certain level of control over the data. A lot of these individual rights are already available to data subjects through the Data Protection Act. So for instance, the right to be informed, the right of access, which is subject access requests, the right to object, and the rights in relation to automated decision making and profiling. They are already there, and you already have these rights as an individual data subject. There are some new rights that the GDPR brings, and they've strengthened some other rights. So the right to erasure, or the right to be forgotten, you may have heard it being referred to. This is about for individuals, if they give you consent to process that data, so if you rely on consent as a legal basis, then they can withdraw that consent and also ask you to delete any data that you hold on them. So they can say, I don't want you to process my data anymore, and I want you to delete all of that data. And you have to be able to evidence that you've deleted all of that data. And you're only able to retain the amount of data necessary to stop you from contacting those people again, so that you know that they've enforced the right to erasure. The right to restrict processing is similar to the right to erasure. They're basically saying that you can continue to store the data, but I don't want you to process it anymore. So I don't want to receive any marketing emails from you anymore. I don't want you to process my data to do any profiling, for instance. You can still store the data that you have, but you cannot process that data any further. The right to data portability is a new one, and this applies again where you've got the consent from the individual to process the data, and you're in the service industry. So the easiest example is gas and electricity providers. If you are one of those businesses and a data subject comes to you and asks you to port their data over to another service provider, so another gas provider, another electricity provider, you have to be able to collect all of that data together in a commonly used format. So on a USB stick, in an Excel spreadsheet, some commonly, goodness me, I can't speak today, commonly used format electronically, so that either the data subject can take that data away with them and take it to any service provider, or you hand it directly to the service provider that they're going to. So you really need to start thinking across the business whether you have the right processes in place to be able to exercise some of these rights. So if an individual comes to you and asks what data you hold on them, to start processing the data, to rectify some incorrect data, maybe you've got an out-of-date address for them, you have to have processes within the business that enable you to comply with that request from the data subject. This is already around with the Data Protection Act. You have to have a lawful reason to process the data. However, it becomes more of a focus point under GDPR because the individual rights that we discussed on the previous page are directly linked to the legal basis for processing. So if you rely on consent to process your data, the individual rights of that data subject are strengthened, and they essentially have greater control over the data and how you process it, what you do with it. You want to really be looking at the data that you're processing and looking for another legal basis to process that data. Consent is essentially the lowest legal basis, the lowest form of legal basis, because it puts the control directly in the data subject's hands, and that can then cause problems from a business point of view for the data that you hold. So you need to be looking at these legal bases for processing and looking at which one suits your business the most. You can only do this if you do the information you hold fully. So if you do your data mapping that we spoke about earlier, you can then look at all your processing activities and decide which legal basis falls under that processing activity. If you're unsure, it is a real strong recommendation for me to get legal advice around your legal basis for processing, because if you use the incorrect basis for processing, so if you use consent, for instance, where you have another legal basis, so if we take processing is necessary for the performance of a contract with the data subject, if you use consent when you could have used that processing is necessary for the performance of a contract basis, that actually makes your processing unlawful. So it's really important that you get this legal basis of processing right. And if you get legal advice, then at least you've got a legal opinion, an external opinion that's trained in data protection that can advise you which one is the correct one to go for your business. So consent, we've spoken a lot about consent through this. It's one of the lowest forms of the legal basis, but also now consent has been strengthened. So under the GDPR, it has to be some form of clear affirmative action. So currently there's a lot of opt-out boxes where it's already pre-ticked and you have to tick it to opt out of the marketing, essentially. So it's already ticked, and if you don't untick the box, you sign up to marketing. That is no longer acceptable if you're going to rely on consent. It's got to be an affirmative, positive action. So they have to opt in, essentially, for the consent to meet the requirements under GDPR. It also must be verifiable, so you have to keep a record of how you've obtained consent, when the consent was given, and how you're advising the data subjects that they have the right to withdraw consent at any time. And this is around the right to object from the individual rights. That must be clear when an individual signs up or consents to the processing. They must also understand very clearly how they can withdraw that consent, how they can object to that processing at any time. So it can't be within terms and conditions anymore. It's got to be separate, and it's got to be clear and easy for the data subject to do, because essentially it has to be as easy to withdraw consent as it was to give consent. So the next step is children. This applies purely when you are directing services to a child. So your services are offered directly to the child. You must ensure that your privacy notice is written in a clear and plain way that that child would understand. Under the new data protection bill, which is what we are going to essentially ratify GDPR into within the UK, they have decided or confirmed that the age of consent will be 13, which is in line with the current Scottish Data Protection Act at the moment. So if the child's 13, the consent is just as it would be for an adult. If they're under 13, you've got to get parental consent, and you also need to be able to verify and document evidence how you got that parental consent if you offer services directly to a child. One of the biggest changes within GDPR is data breach reporting. So whenever a company suffers a data breach, when the GDPR comes into force in May, if a company suffers a data breach that presents a risk to the rights and freedoms of the individuals. So for instance, if you were to email credit card details of some of your customers to the wrong person, so it went to a person that it wasn't intended to, because of the nature of the details that are within that spreadsheet, the credit card details of the data subject, that could really open up the data subject to identity fraud. Where that happens, you now have a mandatory obligation under the GDPR to report that to the ICO. And not only report it to the ICO, but if it does present a risk to the rights and freedoms of the data subject, so identity theft with the credit card details, you need to inform them directly as well. Now you have to report to the ICO within 72 hours of you becoming aware of a data breach. So to be able to comply with this obligation within your businesses, you need to really start thinking about the process and how that would look. So currently, if you have a data breach, does your business get made aware of it? Are your staff aware that they need to report when they've sent an email to the wrong person containing personal information? Are they aware that they need to report a lost USB stick, for instance, that has personally identifiable information on it? And if they do report this, have you got a robust enough process in place to be able to investigate that data breach? How did that data breach occur? Can you contain the data breach? You know, was the USB stick encrypted, for instance? You've got to be able to determine all of these things to be able to report it to the ICO. The ICO has some, or the GDPR rather, has some stipulations about what should be reported to the ICO within the 72 hours. And if you cannot report fully within the 72 hours, you can report in phases, but without undue delay. So you really need to be thinking about this because it's a major change under GDPR. At the moment, there's only the healthcare industry and the telecoms industry that has to report personal data breaches. And now this has been kind of opened up to all businesses if they present a risk to the rights and freedoms of the data subject. So the data breach is an important one to start thinking about. The next step is protection by design and default. This is also called privacy by design within the GDPR, and this is all around implementing the correct technical and organizational measures to show that you have considered the risks that are caused by you processing personally identifiable information. So, for instance, if you process credit card information or you process medical information, the appropriate technical measures and organizational processes that you have in place to protect that data may warrant things such as encryption of the data. You really should be starting to think about protection by design right at the beginning of all your business processes, especially if you're looking to change a business process. So anything that changes the way that you process data, any new software where you're going to store data, you need to start thinking about the privacy risks to that data. There's a thing called data protection impact assessments or privacy impact assessments, they may be called. And these are basically assessments for you to do for any new project that should then highlight any risks to the processing or the project, the data migration, whatever it is that you're doing within the business. And they must be used. So whenever you're making a change to data that you process, you must complete a privacy impact assessment or a data protection impact assessment, whatever you want to call them. And they should be used throughout your project management life cycle. So it shouldn't just be a kind of template that you fill in and then gets put in a drawer somewhere. It really needs to help you manage the risk to processing the data. And when we're talking about awareness of the GDPR right at the beginning of the webinar, this is how you tie up with the ICO to show that you're compliant. So within GDPR, you have to show an evidence that you're compliant. You have to be able to say to the ICO, look, this is how we are compliant. This is what we do to make sure that we reduce the risk and we mitigate any risk that we come across. And this is how we protect and look after our data. And part of the privacy impact assessments, protection by design, is part of that evidence. So if you can't show that you've done a privacy impact assessment, you're unable to evidence how you've assessed that risk to processing that data. So you really need to think about how you embed these impact assessments into your project methodology that you have within the business, or change processes, or whenever you do any process improvement, you really need to think about how you can embed that risk assessment into those processes within your business. So the next thing we're going to talk about is data protection officer. The GDPR mandates that certain people, certain businesses will have to appoint a data protection officer. If you're a public authority, if you carry out large-scale systematic monitoring or processing, or you process any special categories of data, so that could be criminal convictions, offences, medical history, medical information, mental health, anything to do with race and ethnicity, any of those special categories of data, if you process them as your core function within the business, you will need to appoint a data protection officer. The data protection officer that you appoint is a governed role. So there are certain obligations that the data protection officer will have to meet within that role, and they also have to be appropriately trained as well. So they have to be specialists within data protection, law or privacy information, security information. So they have to have the relevant background, and they will assume responsibility and a point of contact for your business should anything happen in terms of a personal data breach. They're the people that the ICO will come to as a point of contact. They will also be responsible within your business for signing off privacy risks, completing privacy impact assessments. They should be the point of contact when investigating any personal data breaches. So regardless of whether the GDPR obliges you to appoint a data protection officer, you have to ensure that your business has sufficient staff and skills to discharge your obligations under the GDPR. And there's several ways that you can do this. You can have a certain team that you put on a kind of enhanced training course around data protection if you haven't currently got those skills within the business, and use them as your internal resource if you don't have to appoint a DPO. If you have to appoint a DPO, or you want to because you consider it best practice for the data that you process, that you can either have a full-time resource employed directly by the business, or you can employ or contract with a virtual data protection officer. So that's somebody outside of your business that you engage with to discharge those functions within your business, to give you advice. And you may not kind of speak to them all the time. It may be a 1 or 2 day a month thing, depending on the size of your business and the data that you process. But that's a good option in terms of a virtual DPO to have a look at for smaller businesses or businesses that don't process that much in terms of special categories of data. This is something you really kind of need to think about. You need to be thinking about it over the next few months. So the last step within the 12 steps of success is titled international. So this is around companies that either operate internationally or that they transfer a lot of data overseas. So if you operate internationally, under the GDPR, you have to elect a supervisory authority that's going to kind of govern your company, essentially. The lead authority will be determined according to where the organisation has the main administration. So if a lot of if your main administration, a lot of your head office, for instance, and control comes from a UK base, then it would make sense to appoint or elect for the ICO to be your supervisory authority. You also need to make sure that when you're doing your data mapping, so right back to the very beginning of the information you hold, when you're undertaking that audit, so when you're looking at where that data is stored and who that data is shared with, you need to have a look at whether the data is shared overseas to what's known as third countries. So countries within the European Economic Area are considered with already adequate safeguards for data protection. Companies outside of that area, so the US, for instance, don't have adequate data protection laws. So you need to start looking at whether you have adequate safeguards in place. And those are achieved by, so for the US, for instance, looking at the Privacy Shield 2.0, using model contract clauses within contracts to those companies that you're transferring data to, or if you're a global company, binding corporate rules, which are a set of rules that the business adopts, and all of the business, regardless of where you are based, whether it be in Africa, in the US, in the UK, in Germany, all operate under those corporate rules. So it's a set of processes that they operate under to process data. So you really kind of need to be looking at that as well from an international viewpoint to make sure that any data you do transfer overseas is adequately protected. Okay, so the next slide that we've got is a summary. So this is a summary for you guys in terms of business recommendations and some information technology recommendations. A lot of GDPR can be achieved by putting in robust policies and processes around how you manage data and what your employees do with that data. So how do they process that data? What's acceptable within your company and what isn't? And that will go a long way to mitigating your risk. Some companies may want to or may need to put in some technology to help them with GDPR. On this summary slide, we have different bullet points, and you can see that there is a selection of ticks, standard bullet points and squares. So where you've got a tick next to the summary point, this is something that RiskX as a company can help support you with. And where you see that you've got squares next to the summary points in the IT recommendations, this is something that Intraline can help support you with as well. So from a GDPR point of view, businesses now really need to be starting to look at the 12 steps and starting to think about what that compliance roadmap looks like. If you haven't already done anything about GDPR, it is recommended that you start to look at the data that you hold. That must be your starting point. Without getting into the detail around the data that you hold, you store, and you process, you won't really be able to meet the obligations within the GDPR, because it's all around understanding that data. So if you haven't done anything around GDPR at the moment, that is the best place to start. And then the rest of the 12 steps can be built on top of that data mapping and the information you hold from a roadmap point of view. And that's it from us at RiskX. Thank you for listening, and I hope you found it useful.
Thank you, Sarah. As there haven't been any questions sent through to me, I'll end off the presentation now, just to say thank you to everyone who attended. I will send out an email after this webinar with my contact details should you require any additional information. Thank you, everyone.